Good afternoon, everybody. Welcome to the Standing Committee on Access to Information, Privacy and Ethics, meeting number 75 today. The bill, speaking about Bill C-58, the Act to amend the Access to Information Act and the Privacy Act, and to make consequential amendments to other acts. And again, today we have the Office of the Information Commissioner of Canada, Susan Legault, to speak. And just for the information of the committee, it's going to be a little bit longer than the 10 minutes. It's around 20 minutes. And also to announce, too, we have some committee business at the end of committee. So whenever that happens, we only have the office here today, the one presenter, so we may have earlier time to exit than we planned. But anyway, go ahead, Commissioner.
Good afternoon. Thank you, Mr. Chair. Bonjour à tous et à tous, honorables.
Good day, everyone. Honorable members, I thank you for having asked me to appear before you to discuss Bill C-58. I followed your work carefully. I've examined the testimony of different witnesses and read the briefs you have received during your study. I've kept them in mind for my testimony today. As you know, there have been strenuous calls for reform on the Access to Information Act. Since the creation of the Office of the Information Commissioner 30 years ago, my predecessors and I have pointed to many weaknesses and shortcomings. In March 2015, I presented a report to Parliament in which I proposed an in-depth rehaul of the Act. The 85 recommendations in the report were to solve the recurring problems linked to access to information and to create a culture of openness. Within the study by this committee in 2016, I have targeted those recommendations of my report that I think should be followed up as priorities during the first phase of the reform. My recommendations are still the priorities I recommend today to update the law. These are also recommendations recommended by the committee in your final report. For example, extend the scope of the law to the Prime Minister's office and the offices of ministers and to institutions that support Parliament and the courts. Legislate a requirement to document the decision-making process on the part of the government. Reduce delays. Encourage the disclosure of information by the government, especially with respect to exemptions, with respect to advice and recommendations, as well as the exemption for confidential cabinet documents. To strengthen the powers of surveillance by the Information Commissioner by legislating a truly binding model with the certification of orders as if they were issued by a federal court. Finally, a mandatory review issued within the Act.
Recommended to the Ministers of Justice and to the Minister of Treasury Board by letter dated December 8, 2017, that an amendment be made during the first phase of amendments to provide for a clear provision preserving the ability of the Information Commissioner to review records over which the exemption of solicitor-client privilege is claimed by government institutions. This recommendation followed the decision of the Supreme Court of Canada in Information and Privacy Commissioner of Alberta versus the Board of Governors of the University of Calgary. Bill C-58 fulfills 2 of these 7 priority recommendations, that is, the mandatory review of the Act every 5 years and the recommendations related to solicitor-client privilege. Le 28 septembre 2017, j'ai déposé un autre rapport
On September 28, 2017, as part of the International Day of the Right to Information, I tabled a report to Parliament entitled Objective Transparency. It describes my reservations with respect to the bill, as well as my recommendations to improve it. I'll answer your questions with pleasure, but now I will concentrate my remarks on some of the problems that have been pointed out in your study and which have not yet been dealt with in detail in my special report.
And judicial independence. The committee has heard from a witness representing the Canadian Superior Court's Judges Association. This witness raised concerns that the proactive disclosure found in Bill C-58 with respect to judges could interfere with judicial independence or could compromise the security of judges. The Canadian Bar Association, in its written submission, has also raised similar concerns. When I tabled my report Striking the Right Balance in 2015, suggesting amendments to modernize the Act, I recommended extending coverage of the Act to the bodies that provide administrative support to the courts, not to the judges themselves. I recognized that judicial independence is a cornerstone of our judicial system and that certain records should be excluded from the purview of the Act. Bill C-58 proposes to proactively disclose individualized information relating to incidental expenditures and representational, travel, and conference allowances, including the judges' names. This, according to the association that presented before this committee, could jeopardize the independence of judges and compromise their security. In order to address these concerns, the association suggested that expense information according to the categories of reimbursable allowances set out in the Judges Act be published according to each court's expenditures. In my view, this recommendation is reasonable and should seriously be considered by this committee. Currently, the expenditures related to these categories of information are not available to the public. As well, the association's recommendation that the decision of whether judicial independence could be undermined by the publication of the proactive disclosure documents could be made to reside with the Chief Justice of the court concerned, and that should also, in my view, be considered by the committee. The second aspect that I want to address, and I think you'll have to be patient with me and bear with me, but this is in relation to personal information. And I thought in preparing the remarks for today that it would actually go into some detail to explain well, basically to go back to basics in a way, how the exemption for personal information is addressed under the Access to Information Act. Based on the testimonies presented to the committee and committee members' questions, it is useful to clarify how the exemption for personal exemption is applied under the Access to Information Act. The personal exemption is found at Section 19 of the Access to Information Act. It is a mandatory exemption. It states that the head of a government institution shall refuse to disclose any record requested under the Access to Information Act that contains personal information. Personal information is defined in Section 3 of the Privacy Act and is incorporated into the Access Act by virtue of Section 19. Personal information means information about an identifiable individual that is recorded in any form, including such things as information related to race, to religion, addresses, fingerprints, and so on. Section 19 of the Access Act provides the following instances where disclosure of personal information is authorized. The individual to whom the information relates consents to the disclosure, the information is publicly available, or the disclosure is in accordance with Section 8 of the Privacy Act. Section 8, in turn, contains a list of instances where personal information can be disclosed. Particularly, Section 8.2m states that personal information may be disclosed for any purpose where, in the opinion of the head of the institution, the public interest in disclosure outweighs any invasion of privacy that could result from the disclosure. The head of the government institution shall notify the Privacy Commissioner in writing of any disclosure of personal information prior to the disclosure under paragraph 8.2m, and the Privacy Commissioner may in turn, if he deems it appropriate, notify the individual to whom the information relates. Section 82M was applied 7,700 times by government institutions in 2015 and 2016. This would have triggered mandatory disclosure requirements by institutions to the Privacy Commissioner. Of the requests completed by government institutions in 15-16, the exemption for personal information was applied by government officials in over 28,000 requests. That's about 39% of the total number of requests. The exemption for personal information is the most frequently cited exemptions by institution. These decisions on disclosure are made by government officials on a routine basis. In terms of complaints to my office, this exemption was cited in over 300 complaints last year, and this is pretty consistent year over year. This makes up 52% of all the exemption complaints that my office reviews. It is important to recognize that the personal exemption is used almost invariably with other exemptions in any complaint to my office. However, most issues related to the personal exemption provision are resolved at the very early stages of our investigations and are very rarely contentious. Indeed, since I have been commissioner, we have dealt with over 13,000 investigations. I have issued a formal recommendation to release personal information in 7 cases. During that time, there have been a total of 21 cases in court related to the personal information exemption under the Access Act. 19 of those were brought forward by third parties, not by the Information Commissioner, and 2 of those cases were brought forward by my office. Although the Privacy Commissioner can intervene in these cases, the current Privacy Commissioner has never done so. Bill C-58 incorporates the Privacy Commissioner into the Information Commissioner's investigative process in 2 instances. First, if institutions notify the Privacy Commissioner of a complaint to my office, the Information Commissioner will have a positive legal obligation under C-58 to seek representations from the Privacy Commissioner. Will institutions feel compelled to notify the Privacy Commissioner? If so, there will be a positive legal obligation to involve the Privacy Commissioner in all of these investigations of the Information Commissioner. No timelines are provided for in this process. We know that this will affect over 300 investigations per year that not only deal with personal information, but with many other investigative issues. Second, the Information Commissioner may consult at her discretion, this is in C-58, when she intends to issue an order that personal information be disclosed. The Privacy Commissioner in his submission proposes to expand his role in access to information investigations further than Bill C-58 already does. He recommends making consultation with his office mandatory when the Information Commissioner intends to issue an order or a recommendation in all instances involving disclosure of personal information. He also recommends that the Privacy Commissioner be able to seek judicial redress where the Information Commissioner makes not just an order, but also a recommendation to disclose personal information. My colleague argues that this involvement of the Privacy Commissioner in the Information Commissioner's investigations is necessary because Bill C-58 changes the balance between access and privacy rights. He argues that the Information Commissioner is a champion of one side of this balance, and therefore the Privacy Commissioner, whom he describes as the champion of privacy, must weigh in to ensure that balance is maintained. Respectfully, I disagree. Bill C-58 does not alter the exemption for personal information that currently exists under the law. it does not significantly alter the definition of personal information. It maintains the tests for public interest disclosure and the obligation for institutions to notify the Privacy Commissioner should they decide to disclose based on public interest. It is true that the Information Commissioner is a champion for transparency in public policy debates. I am, however, first and foremost, a regulator. As such, in conducting the investigations under the legislation, I must apply the law as it is written. The law related to this exemption has not changed. My investigation will consider the same legislation that it has for the last 34 years. The exceptions that allow disclosure at the discretion the exceptions that allow disclosure are at the discretion of the head of the institution. When we conduct investigations in relation to this, our investigative work reviews whether the head of the institution has exercised their discretion in a reasonable manner. The Information Commissioner does not substitute her own exercise of discretion for that of the head of the institution. As I have explained in my special report, given that Bill C-58 does not provide for an actual order-making power, the shift in balance advanced by both the government and the Privacy Commissioner is not grounded in the new provisions of Bill C-58 and is, at best, entirely speculative. Any mandatory obligation to consult the Privacy Commissioner is, in my view, not required and will hinder the efficient investigation of access to information complaints. Most importantly, it will impact the integrity of investigations under the Access to Information Act. This can occur in at least two circumstances. First, since the Office of the Privacy Commissioner is also subject to the Access to Information Act and therefore subject to complaints to my office, a mandatory obligation to consult with his office would create a conflict of interest. Second, it is common for requesters to seek information under both the Information Act and the Privacy Act. They use both acts to maximize the amount of disclosure they will obtain from government institutions. It would directly affect the integrity of the investigations under the Access to Information Act should the Information Commissioner be obligated to disclose information related to these investigations to the Office of the Privacy Commissioner. In sum, for all the reasons above, I do not recommend that the Privacy Commissioner be involved in the investigation of access to information matters where the exemption for personal information is at play, given the existing safeguards that already exists in our respective legislation. The recommendations in my report in this regard should be followed. However, should the committee consider it necessary to involve the Privacy Commissioner into the investigations of the Information Commissioner, I recommend first that consultation with the Privacy Commissioner should be at the discretion of the Information Commissioner, as is provided for already in Bill C-58 under new Section 36.2. Second, that notice to the Privacy Commissioner be given when the report of an investigation sets out an order requiring the institution to disclose a record or a part of a record that the head of the institution refuses to disclose under Section 19 of the Access Act. In essence, I recommend maintaining new Section 37.2. And finally, Section 41.4 of Bill C-58 could be maintained to allow the Privacy Commissioner to apply to court for a review of the orders of the Information Commissioner related to Section 19. Voilà, Monsieur le Président, j'ai été ravie de suivre.
Mr. Chairman, I was delighted to follow your work, and I was also delighted that when the Minister appeared, we learned that the government is ready to hear proposals for changes and to the bill. My report contains 28 recommendations to improve Bill C-58, and I encourage you to look at them during your study. In ending, I'd like to thank the committee, and I'm ready to answer your questions. Thank you.
Off with MP Saini for 10 minutes. 10?
Oh, sorry, 7 minutes.
Or, I mean,
I'll take 10.
Seven.
I would give you 20.
I'm glad he caught me. Good. I saw the eyes get big as saucers, so there was
I knew
7
what you meant.
minutes.
I knew what you meant.
Thank you.
Right. Thank you, Madam Commissioner. Always a pleasure to see you here. Just some points of clarification that I would like to ask you regarding the certification of orders. It's my understanding that the way the bill is drafted, an order from your office would carry the same weight and binding power as a court-certified order without requiring any additional steps. Is this the way you interpret the legislation?
That is not my interpretation of the bill as it currently is drafted. Essentially, if the government institution would basically sit on the order and not provide disclosure as is being ordered, what I would have to do is I would have to take a mandamus application in the federal court, which is part of the federal court legislation. But mandamus application usually take around 18 months. That's my concern, and that's why I'm recommending that there be an added provision that I would be allowed to get the orders certified in the federal court. And I'm told by my general counsel here that those usually take 4 months for contempt of court proceedings.
Okay.
So there is a distinction between a mandamus and a certified order, and that would be the main distinction.
Okay. The other point I want clarification on is the order-making power and the order-making model. I think there is some concern that there may be departments that may be lining up to take you to court. And in Newfoundland, we have the order-making power. Do you find that that's an issue in Newfoundland, or that there is departments that are not complying with the order?
I did go to Newfoundland, by the way, and I met with the Newfoundland Commissioner. I met with various stakeholders involved in their application of their new law, and there hasn't been enough time to see if the Newfoundland model works or not, whether there's more judicial review that's being conducted in court in Newfoundland. What I can say is, from my perspective, under the current regime, we usually resolve most of our cases before going to a formal recommendation under the current Section 37 of the Act. And when we get to those cases, those are, less, there are around 15 cases a year that actually go to that level. Most of the cases get resolved before. When we get there, in most instances, the government institutions agree with our recommendations. There are very few cases that end up going to court. That's under the current regime. I don't see that that's going to change under the regime being proposed by C-58. That's why I don't see that there's going to be the shift in power, the shift in balance that the minister spoke about, that there would be more reluctance from institutions to quote unquote take the information commissioner to court, because that's the current situation. When we get to that final level, essentially it's really two things. Either the government is really strenuously opposing disclosure because it wants to delay the disclosure, or it's because we really have a disagreement on the interpretation of the law. Those are usually the cases where we end up with those formal recommendations. I really don't see that changing under C-58. What would happen is, if the government institutions would agree to abide by my recommendation, then it would become an order in a longer period of time. I normally give them 15 business days. Now we're looking at a longer time period before the order becoming an actual deemed order. So for me, the difference is really that it gives the government more time before it discloses in following my recommendations. That's what C-58 does. In terms of who takes whom to court, under the current regime, if the government refuses disclosure following my formal recommendation, I have the ability to take the matter to court with the complainant's consent, Under C-58, it is the government that will take me to court, or the Information Commissioner, not me personally, but the Information Commissioner.
I hope you not personally.
No.
So another point of clarification when it comes to frivolous and vexatious request. I mean, one of the things that we want to do is make sure that the system does not get bogged down by people making requests in bad faith. How do you see it functioning? What's the mechanism you see to make sure that that doesn't happen?
As I've proposed in my special report, I really don't have an issue with having a provision that would deal with frivolous, vexatious requests or requests made in bad faith. I do take issue with the various components of that in the various ways by which an institution can deny or can decide not to respond to an access request under Bill C-58, and that's laid out in my report. So in terms of the frivolous and vexatious, which is Section 6 sub D, I think, I'm looking at Nancy. So that provision I don't have an issue with. When I issued my recommendations, I was making my recommendations under the basis of an order-making model, like a true order-making model, and I recommended that that would be subject to an appeal to the Information Commissioner. Under the C-58 model, which I do not consider to be a true order-making model, I would recommend that permission be sought to the Information Commissioner before an access request be denied on the grounds of being frivolous, vexatious, or in bad faith.
Some more time?
1 minute.
It's okay then.
Okay, thank you. Thank you, MP Sani. Next up for 7 minutes, MP Kent.
Thank you very much, Chair, and thank you, Commissioner, and to staff for appearing before us today. I must say, starting off, that I've never seen in my previous years as a journalist covering Parliament and legislatures in Canada, or in the almost a decade in government here, such a direct, specific, and unequivocal negative assessment of a piece of government legislation. That said, when the President of the Treasury Board appeared before us, he was equally clear, although he said, as you said, that the government will be pleased to receive proposals from the committee. But he made it clear that they're not likely to be accepted, and he justified that by saying that there was provision for a one-year ministerial review after the coming into force of the bill. Given that, and I've got some detailed questions later, but given that possibility, in fact probability, do you believe that Canadians would be better served by the status quo than what you have very clearly stated is a regression of existing rights?
I think the public will be best served if amendments are made to C-58 to address some of the deficiencies that I've highlighted in my report.
Now, you had 12 red line, and I think 2 topics of neutrality and 1 of concern. If the government, and the government seldom accepts all of the recommendations that come from either committees or from other areas, from commissioners perhaps, if you were to recommend your top 5, what would they be?
I have my top 28. It's one of the
what's the most important?
They're all important. One of the things that the government did promise is to have ministers' offices covered by the Access to Information Act. This piece of legislation does not do that, and I have said that this was one of the priorities in the first phase of amendment. I have said this publicly, that at the very least, the government should ensure that ministers' offices are covered under the Access Act. So I would think that that would be certainly a top priority. The proactive disclosure scheme that's being proposed under C-58, although I fully support proactive disclosure, the concern that I have with the current regime is that it actually results in an important regression of existing access rights in relation to ministers' offices. And this is a real concern of mine, because Section 91 basically says that the Information Commissioner does not have jurisdiction over that Part 2, which is all the proactive disclosure. Now, everything that's in Part 2 right now, all of this proactively disclosed information is currently subject to access to the Access to Information Act. Lists of briefing notes, QP preparation, briefings to heads of institutions, all of this material is currently subject to the Access to Information Act. And if the government institution applies exemptions to that information, those exemptions can be reviewed by the Information Commissioner. Under C-58, if the government applies exemptions to the proactive disclosure documents, those exemptions cannot be reviewed by anyone. And I think that's a real concern. So those would be two of the most important. The third one that is really important is the criteria that have been embedded in C-58 for anyone who wishes to make an access to information request. And I think in that respect, aside from my own recommendation in that respect, you have heard from many requesters that are basically saying that this would be a major regression. And you know, when I was preparing for this committee, I went back to the request that was made by Danielle Leblanc, the journalist that uncovered the sponsorship scandal. And that request would not meet the new requirement under C-58. And that's like a perfect example of how Section 6, as it is currently worded in C-58, would amount to a massive regression. I actually have that request somewhere, but essentially it reads something along the lines of all records related to the sponsorship budget from 1994 to the time of the request, which was 2000. That would not apply. That would not meet the test under Section 6. That would be denied. I think that's a huge problem. The News Media Association did a recent audit of the federal government in order to assess the government's performance. In doing this audit, it sent 29 requests to federal institutions. Out of those 29 requests, when I looked at them, several of them would not have passed the test under the new Section 6. So something like 41% of those requests would not have been valid requests. Last night, before I left my office, one of my directors of investigation told me that an institution had refused to respond to a request, and we had a complaint because the subject matter of the request was not in the request. And Allison here, who's the executive director of investigation, has already completed an investigation where an institution is already applying the criteria in C-58, which are not even in force yet, to deny requests to information. And those are only two that I have complaints about so far. That's the concern I have with the criteria in Section 6. So I'm going to take all of your time if I continue, but there you go. I've just mentioned 3.
30 seconds, I'll cede to the next question.
Okay. Thanks. Next up, for 7 minutes, MP Cullen.
Okay. I'll pick up where we just left off from Mr. Kent's questioning. Is it your testimony that government departments are already beginning to apply C-58 in the denial of information to Canadians?
Yes.
So we don't have to look to some imagined future as to see what potential damage C-58 could do in terms of access to information. We have it already happen. You said 1 or 2 departments.
Well, Allison is here. This is just beginning. This is just the tip of the iceberg.
We haven't even passed the law yet.
Exactly. And Allison investigated a case, and I mentioned it in my special report because that's already a documented case where the institution simply refused to process the request because it didn't meet the criteria of the new Section 6.
And so then the requester, the Canadian seeking this information, has to file a formal complaint. Walk me through the process. They then go to your office and complain and say, wait, because I wasn't, they're tossing this out on a technicality that doesn't exist in law yet.
That does not exist in law yet.
Wow. Okay,
and
so the signal has been sent.
and those are, you know, we were able to report on this complaint because it's completed, and we provided the information in our special report. And I was just informed that there's another one that's come in last night under the same reasons, and that's only because I've now seen complaints. I don't know if requests are being denied by institutions on the basis of that section, but I haven't seen complaints yet.
Right, it's sort of like having a business, and how many bits of grumpy feedback you get is only, they say, 1/10 of how many people are actually upset, because most people won't complain. In your experience, most people won't file the complaint.
That's true.
Right, they won't go through the process. So the number of people that are potentially being denied information that they're lawfully entitled to because they're not being specific enough it's got to be larger than the ones that you're seeing, just by experience.
I strongly suspect that it is, and I'm very concerned about that.
Here's something I'm confused by, because I'm looking at Minister Bryson's statement when they were bringing this bill forward, and he said, and I'm quoting, "We are extending the Access Information Act to ministers' offices and the Prime Minister's office for the first time ever."
C-58 does not do that.
Oh,
I'll give you
that's
an
weird.
example.
Why would he say such a thing?
Well, you have to ask him that.
We did. What he's saying is, and I want to pick up on this, he says, well, we're disclosing it. That's the same. That we're going to disclose the briefing binders, we're going to disclose the question period prep, and some of these other places. So isn't disclosure better than making it applicable, that people don't have to go dig, we're just going to give it to them anyways?
Proactive disclosure, as I said,
It's fine.
in itself is fine. I have no issues with that. I have an issue if it's basically becoming an exclusion to the application of the Access Act, and I do not have oversight when the government actually applies exemptions to that proactively disclosed information.
Okay, so then that briefing book, they apply exemptions to it. They redact, or they just don't disclose it in the first place. Under C-58, you wouldn't be able to then go in and say, what did you exempt and why? And what is the information contained in there, and then make a call for whether the public should have access to that information.
Absolutely.
So the minister's office says, well, I publicly disclosed. They exempted these important pieces that might be damaging or unhappy for the government. That's the end of the story if C-58 becomes law as it is.
Absolutely.
I would appreciate, because I'm sure the example of the sponsorship inquiry and the mess isn't the most happy one for my Liberal colleagues to use as an example. It would be appreciative to us, because we're trying to make this real for Canadians. Why does this matter? Many Canadians don't deal with the Access to Information Act. They don't file complaints. Other examples, if C-58 had been law, in which the information would have not come to the light of day, we've had testimony at this committee about Afghan detainees or the F-35, the war in Afghanistan costs, those types of things that were only garnered because journalists or other Canadians use the Access to Information Act to get information from government that, in those cases at least, they didn't want out, but because the law required it, they had to be revealed. If either now or later, if you could apply, sort of cast backwards and say, if access information had been under this provision, this, and these stories could not have come to light of day. Would you be able to do that for the committee?
Well, I mean, there's already an example in the special report. There are already a few examples provided in the special report. One only has to glean through the published access to information requests that exist, that are publicly available, and any request that does not provide subject matter, type of record, and timeline will be denied under the Access to Information Act under the new provision in C-58. Now, the government has stated that it won't happen this way somehow, that there will be some good measure applied to the interpretation of these sections.
That they'll give out the bad stuff with the good, the damaging stuff with the good.
But in any event, regardless of whether it is provided in good faith by some government institutions, in some instances, what one really has to worry about is when it is not provided because the new provisions are being applied. As a regulator, I cannot recommend or order disclosure of something, or recommend or order an institution to process an access request if the law allows them to deny that request.
So with the little bit of time I have,
I cannot make up the law.
Do you get requesters from First Nations organizations for access to information? things about settling treaty, residential school. These are typical. We had some testimony from Peter Duganji that in terms of his concerns about Bill 58 that are opposed to the bill, you should find yourself in good company. We're still trying to find witnesses who like the bill outside of the government. It will introduce new, I'm quoting, new significant barriers to First Nations and organizations that are trying to access information about their claims, disputes, and grievances. Would you agree with that testimony?
I absolutely agree with the submission of Mr. Duganji and all of the supporters of that submission.
Because in order to have reconciliation, in order to settle claims, in order to figure out things like residential school grievances, it all relies on information. Some information the government just doesn't want out, or has not for 100 years.
As I said in my special report, I strongly recommend that these provisions be removed from Section 6 of the Act as provided in C58.
Thank you, MP Cullen. Next up, for 7 minutes, MP Erskine-Smith.
Thanks very much, and thank you, Commissioner, for coming today and for your work on this. To pick up on something my colleague said, and just for clarification on Section 6, so the idea that the government would be providing additional guidance through TBS and that would resolve some of the concerns, you're simply saying your interpretation of Section 6 doesn't even give you the opportunity to clarify through your order-making powers to better this section at all.
If the law, as provided in C58, allows government institutions to refuse to process a request because it doesn't contain all of those requirements, not just one of them, all of them, subject matter, type of record, and timeline, then they have the legal ability to deny the request.
So just
and
to
I
walk
can't
through,
do anything about it.
So just to walk through Section 6 in detail, because obviously, you know, we had, as a committee, as you know, we recommended a wide variety of things in our report. The government considered that and opted not to proceed with any number of things. And so I think my overriding concern here is certainly to make sure that the legislation is not regressing. Use that word. And to the extent this committee can, maybe we can't apply the Act to ministers' offices and be effective in doing so, but certainly we ought to be effective in making sure that we remove some of these additional hurdles that we didn't suggest, you didn't suggest. So getting through Section 6, so we could remove Section 6.1 sub 1A, which is the request does not meet the requirements set out in Section 6. That would resolve, I think, a large degree of the concerns you've raised right now. What about the person has already been given access to the record or may access the record by other means? And I note, what do I have here? I've got, so you previously recommended a discretionary exemption that would allow institutions to refuse to disclose information that is reasonably available to the requester. We use that language. Is there a concern just in the difference in language here, and one's more restrictive?
The reason why I'm really not a proponent of having an ability to decline to process a request if the information is already available is really based on the experience at our office. Because there is a similar provision now, it's in Section 68. 68, where basically if something is already published or is about to be published, the government can decline to process the request. It's actually it's an exclusion to the application of the Act. And what we found in our investigations is that sometimes information is published on the internet, or sometimes the information is published but it's extremely difficult to find, and we've had to urge institutions to actually disclose the information anyway. So that's why in that particular recommendation, I said that it should be at the discretion, because at least they can consider, you know, if the information is public,
right,
but the actual requester cannot access it easily, it's just a question of assisting the requester.
Okay.
So that could probably work.
Okay, so if it's making it more consistent, presumably with your previous recommendation. And then 6.1 sub 1C, you've indicated concerns about the large number of records. Do you think this would get resolved by your order-making powers? Is there a way to, because ultimately you would have the determination through publishing orders and the jurisprudence you would create to determine what a large number of records means?
Well, there is already a provision in the Act for institutions to get an extension when there is a large number of records, and providing the disclosure would unreasonably interfere with the operation of the institution. That already exists in the current legislation.
Extension rather than a refusal.
It's an extension
Okay.
rather than a refusal. You've heard testimony that there are some of these requests that are bogging down the system, putting gum in the system, 30 million pages, and, you know, you have to look at the facts, right? We're doing evidence-based policy here. And if you look at last year, the average number of pages processed per request across the system, all institutions, is about 200 pages. The two institutions that you've heard from, CIC and CBSA, their average number of records per request, so CIC or IRCC is 53 pages, and CBSA 75 pages. It's true that there are a number of requests that are large, but that could be dealt with the frivolous and vexatious and bad faith.
Oh, so, okay, that maybe answers my next question in terms of, I mean, this seems to be a legitimate problem, this fishing expedition that might take years and of man hours to deal with and really burden the system. But if your suggestions, frivolous and vexatious, would resolve that. With respect to proactive disclosure and oversight, so I'm trying to wrap my head around this. So there are timelines. So right now there's certain information that I can request under the Access to Information Act that is now subject to proactive disclosure, but there are longer timelines, and you don't have oversight. So wouldn't I have been better off going under the current act than proactive disclosure? And and we fix that perhaps by setting more aggressive timelines and giving you oversight. Is that correct?
That would fix it, yes.
Okay, so you raised concerns about publication of publishing your orders and mediation. Briefly maybe expand on that, the importance of putting in writing, I guess, in the Act that you would have these formal mediation authority and you'd be able to publish your orders.
Mm-hmm. The mediation, the reason why I'm recommending that there be a formal provision for mediation is because sometimes, particularly some complainants, do not wish to participate in the mediation process. And I think that the mediation process is extremely helpful in resolving complaints in a more timely way, and I think that that would be helpful. It also puts focus on the mediation process with institutions as well. The certification of orders for me and the publication of orders is because if there is an order, to have it certified in the federal court, as I've explained, if the order is not followed, then we would be in a contempt of court proceeding, which is faster. The publication of orders for me would actually be helpful because it would develop a body of decisions, a body that could be used as precedents for institutions and give guidance, and that we wouldn't be reinvestigating the same issues over and over because we would have this body of orders. And I think that that would be a great benefit to all involved.
Thank you, Mr. Erskine-Smith. Yes, we're at time. The next round will be 5 minutes, starting off with MP Gord. 5 minutes.
Merci, Monsieur le Président. Merci.
Thank you, Mr. Chairman. And thank you, Ms. Legault. I am flabbergasted with Bill C-58 in its present form. We know that the sponsorship scandal would have never seen the day. No one would have learned about it. So to keep information, to keep it from people, well, here we are 15 years later, and things are going to be even more complicated for Canadians to find out what's going on. So what do you think is to be done, Ms. Legault? Well, I've made recommendations to improve C-58, and my recommendations are to remove the more harmful aspects of C-58, and I hope the committee and the government will consider all recommendations to improve the legislation. What about the personal exclusion or exemption? Do you think that this can really harm and impede access to information? I believe that the provision that provides for an exemption for personal information, private information, is something that's existed for more than 30 years and has been interpreted during those 30 years. It's a mandatory thing. And this means that private information is individuals' information and not the government's information. So it's appropriate that we have a mandatory exemption. under Section 8 of our Act, the Office of the Commissioner of Information Act. I think that the Privacy Commissioner would have to give notice to the, we would have to give a notice to the Privacy Commissioner before acting. I think that that would make our investigations just about impossible. And as I explained, not only in terms of efficiency, but also in terms of the integrity of our investigations, it would affect that integrity. Well, it seems we're having a hard time. It's difficult we're having a hard time with the Information Commissioner, the Privacy Commissioner. It seems that this is an attack on all our institutions. Well, I'm here to talk about Bill C-58, as I explained in my report. I'm talking about the concerns I have about the bill and the recommendations that I've made. Besides this, apart from this, it would go beyond the tenor of what I have to say today. Well, it seems with these actions, little by little, we're harming or we're reducing access to information and requiring people to provide information or to completely ignore our institutions. And sooner or later, these institutions may fall altogether if people don't pay attention, if they aren't concerned. It could extend to government machinery. It could lead to an anarchic situation. Is that your question, sir? Was that a question? It's perhaps my little philosophical flight of fancy. Well, I'd like to congratulate you because you've been really courageous to sound the alarm with respect to this bill, and I hope that the committee will be able to make the necessary recommendations to make the necessary changes. If not, it's because we aren't the majority. Thank you.
P. Picard.
Commissaire, Madame, bienvenue.
Welcome, ladies. If I try to, can you give us a more popular definition, a more understandable definition of what you were talking about, of judicial independence? This is something that is protected by the Constitution, and it protects not only against, with respect to judges' decisions. Well, I just wanted to comment. The government pays the salaries of judges. It's an administrative thing. Could it threaten judicial independence? Well, I'm not an expert in constitutional law and judicial independence, but it is clear that at the present time, the information that is in public, for example, and that is in the Judges Act, at the present time, we have the amounts are stipulated. So the Act actually provides for the salaries of individual judges. It's provided for in the Act. What C-58 would do would be to indicate people what judges go to conferences, provide hospitality, etc., etc. This information is very individualized and could affect the independence of the administration of courts. For example, the Chief Justice could decide which judge goes where, is assigned where. I think this is something the committee has to take very seriously and see if, in fact, constitutionality is at stake. Well, there's the whole integrity of our judicial system. Everyone knows that we have expenses that we have to make public. Now, as long as safety of judges is assured, details with respect to their traveling to a conference, this information would be allowed after the fact, and I don't think this would harm judges. Well, another aspect of proactive disclosure that is proposed in C58 is such that if there were questions that would endanger people's independence, judicial independence, then it would be appropriate to apply the exemptions, especially as regards people's safety. And there are exemptions in the bill to protect judicial independence, but since it is a constitutional principle, I think that judges think that their independence is at stake, and they would like to see these parts redacted. I'm not an expert in the field, and in preparing my presentation today, we didn't have the benefit of a brief that was given before the committee with respect to what had been said before committee and the committee reports. So we don't have all the information either to analyze this in detail, but I wanted to bring to the committee's attention in my presentation, since this gentleman was the only of your witnesses to deal with this, and I think that his recommendations are some that would go halfway to providing information for the in toto amounts. I think that this deserves the consideration of the committee. So we would be negotiating a compromise to satisfy those who want information while maintaining aspects of personal safety. Yes, I think that's quite possible, and we didn't have the benefit of the complete brief, but Mr. Boisvenu, or rather Mr. Bienvenu, really were bienvenue or welcome. Thank you.
Up MP Kent for another 5 minutes.
Thank you very much, Chair. And I'd just like to come back to the disclosure of personal information, and I'm sure you saw the presentation from the Privacy Commissioner before us and his arguments that C58 would disrupt a balance that he sees between your two offices. And he invokes the quasi-constitutional nature of his office, which I assume you would counter with the quasi-constitutional nature of your office and Canadians' right to access to information. He recognizes your significant experience over the years but his qualification, his reluctance would seem to not offer a positive response to your suggestion of discretion. Do you think that some mention of discretion in the application and your decision in his inclusion or not in the process would be a solution?
What I'm saying is that if the committee and if Parliament decides that there really has to be some measure of involvement of the Privacy Commissioner under C58, that it should be first, in terms of consulting the Privacy Commissioner during investigations under my legislation, that it be at the discretion of the Information Commissioner. The reason I say this is because of what I highlighted in my remarks, but because most of the cases get resolved very, at the very early stages of investigation. And the way C58 is currently drafted, if a government institution decides, it's basically open to them to decide to notify the privacy commissioner as soon as they receive the notice of a complaint. And if that occurs, then I shall consult with the privacy commissioner. And in that respect, I think that would really impede the investigation and affect the integrity of the investigation. If it is at the discretion of the information commissioner to consult, it would be in very few cases where I would say that there would be contentious issue between the two offices. We really have a long history, over 34 years, of these two offices functioning in the interpretation of that section. And there has been very, very few instances of disagreement. So that's why. And then the Bill C-58 already provides that if there's going to be an order, so there's a recommendation, and if there's going to be an order, the time for the government to respond, or the time before the order becomes a deemed order, there has to be a notification to the privacy commissioner, and there is an opportunity for the privacy commissioner to bring the matter to court. So that process is already provided for in C-58. What the privacy commissioner recommends, if I understood correctly, is that even at the level of a recommendation, that he would have to be notified. And that's what we have now. We have that regime now. We do make recommendations to institutions on a regular basis. Very few instances deal with recommendations to disclose personal information, and I have no obligation to consult with the Privacy Commission. That's been the case for 34 years. So, you know.
This comes back to your figures, the 13,000 cases and the 7 personal requests. Can you describe what those 7 personal, just characterize what those 7 would represent?
But this is something that we can provide to the committee, actually, because we have them.
Sure, but because they are exceptions, they would all fall into a similar set of considerations, or would their exceptionality be?
I can tell you.
We do have them.
Yeah, I have. There's one. You go ahead. Oh.
Well, actually, there are 2 cases that went to court recently. One was dealing with a request to the Prime Minister's office in relation to information related to Senator Duffy, Senator Brazo, Senator Wallin, and that was in the federal court. We recently had a decision, and that involved some information that the Prime Minister's office considered to be personal information, and I disputed that before the federal court. The issue was whether or not the information was a discretionary benefit or not. The court has actually decided in accordance with what we proposed in the most part. That decision is not entirely in the public domain because it's under appeal. That's one instance, that's one example, that's one of the few examples. And the Privacy Commissioner could have intervened in that case. There is that ability to intervene in those cases exists under the current regime.
And I assume he didn't at time?
No.
Okay.
Thank you, MP Kent. We're going to have lots of time for questions after the round is done. So up next for 5 minutes, MP Fortier.
I'll give my time to...
Go ahead. 5 minutes.
Thank you. I want to come back to clause number 6, and I looked at it here. It's asking for 3 things. You know, when you make a request, what's the subject? What type of record are you looking for? And what time period? To me, that sounds exceedingly reasonable. And then I read also what it's meant here. It's meant to provide an experienced employee, not even a new one, but an experienced employee of the institution, help to identify the record within a reasonable effort. So I find that part actually exceedingly reasonable. Then we received testimony from Canadian Border Services Agency and IRCC, and they welcome this clause because they believe it'll make them more efficient in fulfilling the ATIPs. But you're against it. So the people that are, it seems reasonable to me, the people that have to do the work seeing it's reasonable, but you're saying that it's not reasonable.
I'm the information commissioner. I don't make the access to information requests. Requesters make access to information requests. Governments have to respond to access to information requests. You can see,
Fashion, no less.
you can see that it's perfectly understandable for government institution representatives to say that these are good amendments because it allows them to not process access requests
I don't think that's what I disagree with that point there. I don't think they're saying that they don't want to process them. In fact, if I look at the percentages, these two groups process they process 60% of all access to information requests. So I would take a completely different approach than the one you're taking, Ms. Legault, where you're saying, well, the people that do the majority of the work have asked for what seems to me an extremely reasonable thing. Tell us what you're asking for, the time frame, what you're looking for, so that we can be more efficient. And you're presenting it as they're just saying that so they can say no to everything. That doesn't jive with me.
What I'm saying is what is being proposed in the new Section 6 in C58 is a regression of existing rights. Under the current legislation, if I make an access request for all records related to sponsorship budget, I would be able to have my access to information processed. If I made an access to information request in relation to all records related to Afghan detainees, I would be able to get my access request responded to. Under C58, that would not be responded to.
Let's stay with the two that do the majority, the brunt of the work for our government, IRCC and CBSA. So let's stay with these that do 60%, more than 50%. They do 60% of all requests. They've said that these very reasonable parameters, you're saying it's a regression. I understand you're saying it's a regression. We've also heard from many people that they want efficiency. And the people that do the brunt of the work say that giving us this little bit of information will help us be more efficient. And you say, well, that's a regression. I don't agree with that assessment. I think that's progress. I think that asking to be, that's an attempt at being more efficient, and simply asking for this seems reasonable to me. I understand there might be the Afghan detainee one. We'll put that aside. Let's deal with the brunt of the business. How is it a regression for the people in IRCC or the people in CBSA? And why would they want to use that?
Well, I think you'd have to ask them because they don't.
You ask them. They said it's good.
Yes. So they don't see it as a regression, and I fully respect your perspective on this. I have, this
I don't have a
this
perspective. I'm just trying to align what you're saying to what they're saying.
But what I'm saying is that what I consider to be perfectly valid requests under the current regime will now be denied under this regime. I think that you've heard from Peter DeGangi, and his submission is supported by a number of First Nations, and I think that their concerns with this new section are entirely legitimate because they don't necessarily know all of these three criteria.
You keep diverting it away from. I've asked a specific question about Canada Border Services, IRCC. They do the brunt of the work. They say it's useful. Tell me why you don't want to listen to them. Not about the others, about to them.
Oh, I'm listening to them. And in fact, if you really want to look at the types of requests that they get at CIC and CBSA, that might not be a problem for them because as they have testified, most of the requests at CIC are really about
So it's not
the
a bad idea
status.
for them.
No, I'm saying that the bulk of the requests in those two institutions deal with very specific matters.
So it's not a bad request for them, right? It's not a bad thing for them to have, you're saying.
Well, I think it's a regression for access to information rights generally.
I'm not talking about general. I'm talking about
time is...
but I think it's important to recognize that these provisions do not only apply, or would not only apply to one department. They apply across the system over 250 institutions.
Time is up. Thank you, Mr. Bayless. Next up, MP Cullen for 3 minutes.
Wow, I just heard the statement, putting aside the Afghan detainee situation in which Canada may have violated the Geneva Convention. The notion I'm struck with is Because I find I'm now looking a little bit more worrisome at the testimony that we had from the two departments that came ahead, because they raised the specter of 10 million pages of requests coming in, or a request that would then elicit 10 million pages of documents that come forward. You've testified today that that is the average is dramatically less than that from those very departments. I then raise a question over the veracity of the testimony that was given to us, because the specter of these clogging the wheels of government requests that were coming in is not what your experience has been with those specific departments. Is that fair to say?
No, it's fair to say, yes. The total number of pages provided to Canadians last year, according to government statistics, is a little bit under 7 million. Total for all institutions.
But they said there was one request that would have cost them 10 million pages, just that one request alone. And your testimony today, based on government facts, because it's good to have evidence-based decision-making, is that the total for all requests from all Canadians, for all departments in the federal government, was 7 million.
Last year. I have the exact number here.
Okay.
6,966,589.
So while I understand that it's inconvenient for government sometimes to have to respond to these requests, we see that some requests from government take 4 years or more to answer. Is it fair to make the statement, as it has been up by other witnesses, that access to information delayed is access to information denied? That you raised the example of the Duffy, Wallen, Brazeau example. That's still going on. It was an access to information to the Prime Minister's office that is still being contested back and forth, months, in some cases now a couple of years after the incident and the concern was first raised to Canadians. 3 years. You're nodding. I just want to make sure it's on record as true. I want to go back to the question, because this preoccupies me, and committee members could forgive me, but I represent a constituency of approximately 40% First Nations people in the northwest of British Columbia. Some of the treaties still unresolved. One took 135 years to resolve. That there's a great deal of hope and promise with the new government, because there was this commitment to reconcile, a word that has been so stretched in its application that I'm wondering about its meaning anymore, around specific things like reconciling around residential schools and the horrors that went on there, around reconciling land disputes, which is the heart of enfranchisement for First Nations people. If C-58 were to become law, from your perspective as Commissioner, would the ability to reconcile, to resolve, to settle cases be enhanced or diminished based on what information First Nations would be able to pull from the Government of Canada?
You know, I'm the Access to Information Commissioner. What I can say is that if C-58 and Section 6 remains as it stands, it would be a lot more difficult for First Nations to access the information that they need to establish land claims and to establish some of past events that they might have been involved in and that they need to document in order to resolve.
That should weigh on all of us as we consider amendments to this bill.
So now we're going to continue. I assume there's still questions to be asked of the Commissioner. We're now to open time, so you just need to let Hugh know that you're on and would like to ask a question. And I would say we'll keep the questions to 5 minutes, and we'll time out the clock until we need that 10 minutes at the end for committee business. So next up, I believe, is MP Dubourg.
Merci beaucoup, Monsieur le Président. Donc,
thank you, Mr. Chairman, and I would also like to say hello to you and the people you're with. A brief question first. Two brief questions. The first one, we're talking about the Conservatives' election platform. They had various points saying,
release of information, expand the coverage of the act to all crowns, corporations, etc., etc. Bon, on sait qu'après 10 ans, effectivement, il n'y a rien.
We know after 10 years, nothing had been done. And I wanted to point out an article in the Canadian press where they say,
found evidence of systemic interference with access to information requests by 3 conservative staff members, etc., etc. Est-ce que d'après vous, et avec les amendements que vous avez...
In your opinion, and given the amendments you proposed, does this mean that it will no longer be possible to have this kind of interference with respect to requests? I don't have the article you have referred to, nor the date, so it would be difficult for me to answer your question in an intelligent way. There's nothing in C-58 which, at first blush, addresses political interference. I think we have carried out several investigations to that end. Since we've made our investigation, I haven't had knowledge of any kind of actions of this sort in government institutions. Well, perhaps I misused the term. They talk about systemic interference, not political interference, because there are 2 reports you tabled, interference in access to information, and it referred to that when people tried to interfere with the system, that there were measures to not allow the system to not work properly? Or is there no relationship between these things? If I've understood your question, Mr. Dubourg, you're referring to frivolous questions, vexatious questions, and in my experience, and it's been some time since I've been the commissioner, there have been very few cases that have been brought to my attention, sort of on the periphery of access to information issues. It's true. It's true that there are very rare cases where there are or might be abuses of the access to information system, and I believe that the provisions in C-58 and 6D, which deals with vexatious, frivolous, or bad faith, I think it could be appropriate to allow institutions and the commissioner to deal with these issues. Thank you. We all know as parliamentarians that in our administrative regulations, we have to use funds allocated to us as members of parliament. We have to use these funds properly. When I came here in 2013, there was discussion of misuse of funds by the NDP, that in their householders, having satellite offices. And it's true that at the time, we didn't have this proactive disclosure, but now that we have decided to put this in place, just as we decided to bring in the publication of ministers' letters of mandate, I think that, don't you think that with this we could prevent this kind of action on the part of parliamentarians? That is, to misuse parliamentary funds. Mr. Chairman, you'll understand that it's really not appropriate for me to make comments on how funds are used by parliamentarians. This said, as I mentioned earlier, any proactive disclosure is quite welcome and appropriate as long as it is subject to the supervision of the Information Commissioner.
5-minute round. We'll go to MP Cullen.
Just a question about what this whole notion of vexatious or too many documents. What is too many? I think you noted in your submission that a large number, who determines what a large number is? You sort of have 1,000 pages as a benchmark, your office does. Above that's considered large, below that not. But I notice Treasury Board thinks 500. Is there a, what worries me in the Act is these C-58 is these subjective terms, and that the application of vexatious or too large or inconvenient to government is defined by who? Can you help us out there?
Yeah, I have a lot of concern with that provision that would allow institutions to refuse to process requests when there is such a large number of records. I think that the provision that exists now are sufficient. There is a duty to assist that exists.
Yeah.
The request has to be sufficiently detailed so that a reasonable employee in an institution can assess what it is.
So let me go there just for a second, because the government has portrayed this as we're trying to help people get to the right by forcing them to subject and matter. So if somebody writes in a general request, the duty to assist within that department says, I'm going to correspond with the requester and say, I would like to help you out, narrow your request so that I can get you the information that you want. That exists right now?
Yes.
So requiring it in law, and if it's not there up front, then the request can be denied under C-58.
Yes.
Okay, so that's less helpful. Right? If the current practice is somebody writes in and they're not specific, they're asking a very broad thing, and the Department of Justice or Transport says, this is so broad, correspond back with them in our Access to Information Department and find out, can we help you? Is it this part of the rail service or that part? And the requester can then have a correspondence and get the information that they want to avoid the department having to spend millions of dollars or whatever the scenario is. That's the current practice?
The current practice is to try and assess what the requester is really looking for and to assist them in formulating their requests in a way that is appropriate.
To help, because Canadians don't know what the Access to Information Act always applies to. They don't know the internal workings of the departments. They're just trying to find out noise from trains going through Canadian towns and what the regulations are, but they're not going to know specifically where, when, and what, and the department should help them find that out.
Yeah, and there's another issue here. There are instances where requesters do not want to provide all of those three requirements when they're making a request. Why not? Well, if you're an investigative journalist, like Daniel Leblanc was in 2000, he wanted to have a broad spectrum to basically see the records that would be related to the sponsorship budget. You know, one other issue that was mentioned by some of your witnesses from institutions is people requesting subject headers. Well, you know, the requester sometimes requests a list of subject headers because then they only ask specific requests for certain emails or certain information. We've had complaints related to that, so I fully understand that practice.
So without the definition, I'm imagining back, and I'm in the Department of Defense, and somebody has made a request about the transfer of detainees in Afghanistan, a pretty sensitive topic. If I were to deem that as vexatious, this is somebody who's just looking to attack the Canadian military unfairly, put us in the news in an with no other definition, could that request then have been denied under terms of vexatiousness?
It could potentially.
I'm not saying would it have.
Based on what C-58 does, yes, it could, because it could regenerate a large number of requests. It could be denied because it's not specific enough and doesn't meet the criteria in Section 6.
Which detainee to which prison to which date?
Even if you were just to say all records in relation to Afghan detainees.
That would be too broad and would be denied.
Of course.
Okay. So this, the point of this is to hold government to account. That's the whole point of the Act. That's the whole point of your office. I think there's this, because I have a request into the Pilotage Authority that I've used in this committee as an example. It went over 300 pages, most of it redacted over an incident that happened in my riding, so I could relate it back to the people I represent, just to tell them what happened. I can't tell them what happened, because even under the current, I have to go appeal this. So I know I'm going to run short of time. What I find concerning about the line, because we just heard the Prime Minister talk about how much he respects you in the House of Commons today during question period. Not you specifically, but all the office holders, and that we all, the Ethics Commissioner and all that. Your recommendations are very specific in order for this Act to do its job. I'm getting to the point of wondering, if not amended, if unamended, C-58 does not follow the principle of do no harm under legislation, that you shouldn't introduce bills that make things worse. Your broad assessment is this is broadly regressive, broadly unhelpful to Canadians getting information that they deserve and need. Is that right?
I would agree with you that if C-58 is not amended in a significant manner, then I would much prefer to keep the status quo.
Okay, that is time. MP Cullen. Next up for 5 minutes, MP Kent.
Thank you again, Chair. I'd just like to come back briefly to the matter of fees, and you reminded us that in 2015-16 the government collected a total of under $400,000 in fees, which certainly meant the expenditure of considerably more than that to collect and process. You also say in your statement, your message, that C-58 not only reintroduces fees but leaves the door open for a variety of ways to increase fees, and I wonder if you could speak to that.
Certainly. Currently, the Access to Information Act provides very specifically when fees can be incurred. And the government back in May of 2016, if I'm not wrong, issued an interim directive that no fees at all. And that was very welcoming for requesters. The current proposal in Bill C-58 proposes to introduce fees without, in the Act, explaining what kind of fees could be. What it says that an application fee could go up to $25, but I believe that Minister Bryson has said that for now it'll stay at $5, but the Act will allow to bring it up to $25, and that any other fees that could be imposed would be done by regulation. And we do not know what will be in those regulations. And of course, it's a lot easier to pass regulation than make amendments to the Act, as we all know, and therefore that's the risk. And as the Commissioner's report states, at the end of the day, is it worth it? And really, quasi-constitutional right of access, this is information that belongs to Canadians. Should there be fees at all? And that's the worry.
Thank you. Well, and then to the Commissioner, of your 12 red lines, this would not be a make or break matter should the government ignore that recommendation. I mean, it would not be in the top rank of red lines that you addressed off the beginning of the session.
I will say that fees have been the bane of this Information Commissioner's existence.
Really?
In the sense that I profoundly disagree with the charging of fees. The experience I've had with the charging of fees on the Access Act over the years, I've seen a whole bunch of stuff. Abuses by government institutions using large fee assessments in order to not process access requests. It leads to complaints. We have to, do the investigations. Until all of this is done, no information is even disclosed. So I just think it's not a cost recovery system. If you were going to make it a cost recovery system, you'd have to charge around $900 per access to information request, because that's roughly the estimate of the cost that the government is putting forward. It's not a cost recovery system. I think the government has to decide, as it does with the implementation of the Official Languages Act, that this is a value that we have in our democratic society, that this is part and parcel of the work that public servants and that public institutions give to Canadians, that it is how we respect our quasi-constitutional rights. And really, in this day and age, with this whole movement of open government, where we're basically saying we're going to provide open data for free. We've signed a charter basically stating we're going to provide open data for free. Well, let's just give Canadians their information for free, shall we?
And just finally, so to get your specific characterization, you've said that Bill C-58 is a regression of existing rights. How would you characterize it with regards to open government? I take from what you've just said that it would be an affront to the concept of open government.
I just don't think it's going to help the government's public policy objective of fostering open government. I mean, this committee has done an extensive study on the amendments that should be done. I certainly have done an extensive study on the amendments that should be done. These were really meant to foster and to really develop a culture of openness within government institutions. The bill that's before us in C-58 really addresses some of the concerns that access to information professionals have in responding to access requests within government institutions. That's really evident from this bill. Does it address requesters' desire to access easily and in a timely manner government information? It doesn't. It doesn't address any of the recommendations that both this committee and I have made in relation to exemptions, in relation to timeliness, in relation to full coverage, in relation to a full order-making power. It doesn't do that. The government is stating that this is the first phase. My hope, and it is my most sincere hope, is that the work of this committee and that Parliament will actually ensure that this first phase moves the yardstick forward in matters of access to information. Even if it is just a little bit forward, forward is a positive result.
Thank you,
if
Commissioner.
It goes backwards, then that's a regression.
Next up, for 5 minutes, MP Erskine-Smith.
And that comment is a perfect lead-in to, I think, what we want to accomplish as well. And I've got a few small questions. One is, in your recommendation, that all complaints be subject to the same process. It makes sense that we ought to defer to your office, whether it's you or your successor will ultimately be dealing with order-making powers. And does it make any sense to have this dual-track system, to have order-making powers in relation to one set and the current state of affairs in relation to the second set? Would that complicate things in your office?
It definitely would complicate things in my office. The transition period, in my view, would have been required if any changes had been made to the actual exemptions. That would have created a difference, in my view, in terms of the transition period.
Order making, not so much.
But there are no changes to the exemption regime, so I don't see any problem doing all the investigations under a new regime.
A small question, but we've heard some testimony about InfoSource and the removal of InfoSource, and one's perhaps solution, and open the floor to you, would be keeping Section 5 but encouraging a digitized version of InfoSource, but keeping it in the spirit of what the intention was from when it was first enacted.
Oh, I think so, and I think that InfoSource needs to be modernized. There's no doubt about it, even if it's in component. Be wary of providing something only in digital format, however, because sometimes when we do that, we actually limit access for certain people who do not have access to digital environments.
One thing we haven't really heard information about is the extension of the timeline for tabling of the departmental reports and their compliance with the Access to Information Act. Perhaps you could speak briefly to whether that extension makes sense and the rationale for it and what this committee ought to do.
The extension of the timeline for that is, to me, not a very positive thing, because I've been recommending for some time now that the government actually produce the information, the statistical data, on a quarterly basis in an open format and reusable format. I actually use these statistics quite a lot, and they assist basically everyone to hold the governments to account in its performance. And what happens now is that we usually get these trickling in the spring, continues until September, but now this would be in September, I believe, and that's very late in the day, because that's performance reporting on the previous year, as you know.
So, and the last short question I have is in relation to proactive disclosure, because so if you had oversight powers of proactive disclosure and there was something blacked out, this is my understanding, correct me if I'm wrong, is that the exemptions would still apply in the Act. So if something was blacked out in an appropriate way because it related to advice and recommendations, if it related to cabinet confidence, which I understand you would not perhaps be able to review because of an exclusion, but any other exemption you would review and you would say, yes, this is properly blacked out. And I mean, ought the government to have any worry there, given you have that power as it is under the Access to Information Act, right? Okay, so you mentioned a culture of openness, and we heard a lot of testimony about a culture of delay in our original study, and it's funny to listen to some of the colleagues on the other side insist upon a culture of openness, given that culture of delay was fostered under Stephen Harper for 10 years. But
the whole side, all right.
Not the whole side. But I take some of the worry is that because of that culture of delay has solidified in some ways that we can't give additional powers to say no. That's your worry is expressed in certain ways in your recommendations. So a broad question, but if we look to fix Section 6 to the extent we're able to do so and find a compromise there, give you oversight on proactive disclosure, insist upon a timeline for the mandate letter or improved timelines, publication and mediation, all complaints be subject to the same process, info source, the government reports of compliance with the Act. You would say it would be a small step forward, perhaps, but you said your sincere hope is that it would be a move forward. With those changes in hand, you would say that would be a move forward and it would be a positive step for this Act?
Certification of orders?
Yeah, okay. Yeah, let's add certification of orders, sure. Right.
Frivolous and vexatious limited to 6D and not the other components of that.
Okay.
I think that's way too broad, especially in the first phase. Having the frivolous and vexatious reviewed by, get permission from the Information Commissioner. Essentially all of the recommendations really is what I'm looking for.
Okay, well, thanks very much.
Is that good?
You're under time. Thank you, Mr. Erskine-Smith. Next, last name I have on the list is MP Bayless. So if you still want to ask a question, please let us know. MP Bayless for 5 minutes.
Thank you. I'd like to understand some of the, there's another area where you don't seem to agree, which is with the Commissioner of Privacy. I'd like to understand a bit more about that issue there. You gave some statistics, which I tried to write down, but I didn't have you didn't provide a written document of your testimony.
We will. I apologize
I'd like that access to that information, but...
Yeah. No, we will provide it.
There you go.
We just didn't have time to translate it.
Yeah. I hope it's under 73 pages or whatever, 53. So you'd said that there was it 300 that you said when the most frequently cited complaint you have is that there's a denial due to the fact that there's a question about access to private information. Is that right?
Yeah.
And you said there's 300 complaints a year approximately?
Yeah.
Okay. And you said 52% of all exemption complaints are related to this? So whenever someone says, no, I can't give it to you, it's related to privacy? 52% of the time, is that right? And then people might turn around and complain, and that you got 300 complaints.
No, what I mean is, of those 300 complaints in my office,
52% of those were?
That represents 300 complaints where personal information exemption is applied, represent about half of all the exemption complaints that we have. Exemption complaints dealing with national security, investigations.
So you got like about 600 complaints, of which 52%, so a little under 600, 300 are to do with access.
Contain a personal exemption application.
Yeah,
so they would have other exemptions, but they would have that one.
So about half of them. Then you said there was, I got lost in your testimony. There were 13,000 instances of what? What was the instance? 13,000.
13,000 investigations you've completed since your
It's since I've been commissioner, we've had 13,000 investigations overall. Over the years that I've been commissioner, the office has completed slightly over 13,000
investigations
cases.
of denials, investigations of.
That's writ large. That includes all types of investigations.
Okay. And then you had 7 cases, which you brought back then to personal information. What, you said there's 7 cases that went to court, is that?
No, 7 cases where we made formal recommendations. That means at the last level. Cases where we did not resolve the investigations. The point I'm making is there are very few cases where we go to the ultimate step of making a formal recommendations to the government for disclosure, which involve personal information exemption.
Okay, so 7 times you were not able to resolve it.
Correct.
Okay.
Well, actually, 5 of those eventually got resolved. So
Now,
only 2 went to court.
In the privacy commissioner, I understood his testimonies as, and he made the argument that he's a balance. You want to put information out, given everything, all else being equal, you want to put it out. He wants to hold it back. I mean, it's a natural balance. And
But I
he would say,
disagree with that statement from
Okay,
the
well,
privacy
that's-
commissioner.
Go ahead.
The information commissioner and the privacy commissioners are regulators. We have to apply the law, as I stated. The personal exemption in the Access to Information Act is a law. It's a provision in a law that is very well defined. And
But
it's
he wants
actually
to, yeah, and if I understand him, he wants to apply what he thinks is his purview, which is privacy, and you're saying, no, don't bother, I'll do it.
But we always do it.
Whether
That's
you
the
always,
point.
whether, yeah, okay.
We have to do it under the
If we
current
always do it, then I don't
legislation.
need to be sitting here, because what the heck, we always did it that way. So that's not a good answer to me. He's trying
But
to,
that is the legal answer, sir. It's the legal answer. When I apply the exemption for personal information, I have to apply the definition of personal information. I have to respect what the personal
So I should
information
explain-
exemption states
Okay,
in
so-
the Act. I
so-
can't just supersede
so
that.
I have to go back to the privacy commissioner and explain to him that's the law, and he's wrong? Is that what I have to do?
I disagree with his comments that the current C-58 changes the interpretation of the personal information exemption or changes the balance between the access to information and the privacy information.
Where does he want to insert himself in the process between this 13,000, the 300, the 7? At what point does he say, I need to insert myself? You disagree with him. I get that. He says that he has his job to do. You say, don't worry. It's always been this way. It can stay this way. And it's my job. I'll do your job or his job or your job. But where does he want to insert himself into the process?
Well, I think you should ask him that.
We're at time. So we have another question from MP Cullen. Assures me that's going to be less than 5 minutes.
sir.
We have about 5 minutes left, so go ahead.
That's helpful. You just cut me off. I'm getting used to it. Running over. So let's just pick up on Mr. You can do it again. It's true. Where Mr. Bayless was going there. This idea of the personal information exemption sits in Canadian statute and law, which you are by law required to apply.
Exactly.
The privacy, give me the exact moment or the specific disagreement again that you have with the privacy commissioner's interpretation as the way things are right now.
Mm-hmm. Under the way things are right now, the privacy commissioner is not involved in our investigations at all.
Right.
The information commissioners over the last 34 years have interpreted and have applied and have made recommendations in relation to the application of the personal exemption contained in the
Let me
Access
ask
to
that.
Information
Have
Act.
you or previous commissioners been found in court to have applied that incorrectly, allowed too much personal information out that has contravened the personal information exemption?
There's one case where
There is one case where the commissioner recommended that personal information be disclosed. It went to court,
Yes.
and the judge did find that it was personal information.
So
It should have
in-
been
in
released. So there's been one.
One case in 34 years in which you wanting to release information
Yeah.
that had some, that was uncertain as to whether that was
Yes.
too much,
Mhm.
where a judge said, that's too far, you can't go You can't give that information out.
And I have to qualify that because there is a reason why I decided to take that case to court. It's because we had several cases with the same complainant in relation to the same information with several institutions, and we were unable to resolve the matter until we got a determination from the court on the interpretation of that
in that one case in
information.
34 years, which the Information Commissioner's Office took this question that Mr. Bayless is.
That's under my mandate.
Let's stay with the last 8 years then.
That's the one that I know.
So in the last, we can go back and you can provide us with any other cases.
We can provide that information for
So the
sure.
concern Mr. Bayless is raising is that perhaps the Information Commissioner, in your desire to make as much information as possible, is not curtailed enough by the laws as they are, the interpretation of the law. You've told us in the last 8 years, the one time that you had to go to court to resolve such a concern was to find out where the limits actually were, which you did, and then moved on.
And the Privacy Commissioner
Yes.
could have intervened in that case under the current regime.
And chose not to.
Exactly.
So going ahead, that would remain the case under the amendments that you suggested to us, that if the Privacy Commissioner had concerns like Mr. Bayless has suggested, could intervene at that point and say, I think there's too much information that's about to be divulged.
Yes.
I disagree. I'm going to argue on behalf.
Yes, basically, the
There's no complaints.
Well, then there's that.
Either. But there's been no.
No, correct. I mean, C-58 does provide for the Information Commissioner to be notified if there is to be a recommendation that will become in order, gives them time to actually decide whether or not to challenge the decision in the federal court, which is exactly the same regime that we have now, which has worked for 34 years.
Okay. And you'd agree sunlight is the best disinfectant, right?
Of course.
That's it. Thanks.
Thank you, Mr. Cullen. I just have one question as chair for the commissioner. We've heard it from different people around our committee that we heard it from the Privacy Commissioner as well. Talk about the struggle between your two offices, and we've heard about that several times. I just wanted to ask you one question. In your opinion, what is a higher priority for you, the preservation of information or the preservation of privacy?
The greater consideration for me is to ensure that as a regulator, when I make a determination on this issue, that I apply the provision that is provided for in the Act as it has been interpreted by the case law over the last 34 years.
You didn't answer the question, but...
But that is the actual answer. That is the actual answer, Mr. President.
But,
that is the answer.
Given the two options, you chose a different answer. Can I ask you the question just one more time? What is the higher priority for your office, the preservation of information or the preservation of privacy?
It's the same. What I'm saying is that I am a regulator that has to apply the law. In the law, for instance, if you ask me the same question in relation to national security, and you would ask me, what is my greatest consideration? Is it the disclosure of information that is related to national security, or is it the preservation of national security interest? My response would be that I have to apply Section 15 in the Access to Information Act and apply the existing case law that applies to this national security exemption. And my job as a regulator is to ensure that my recommendations or my orders in relation to that provision are compliant with the law. That's what I have to do. And those are the bases that my recommendations are based on. I always have to weigh both the interests of transparency and the interest of secrecy. That is exactly what I do, whether it's personal information, national security, investigations of law enforcement bodies, or commercially sensitive information. My job is always to weigh and balance those interests that are embedded in the Access to Information Act.
Thank you, Madam Commissioner, and thank you for appearing before our committee today. I will briefly suspend, and we'll go into camera and discuss committee business for the next about 8 minutes. So thank you. Suspending.